There are various challenges when it comes to a company succession. One of the legal hurdles on the path to company succession are minority holdings. Minority shares in a family business may not be counted towards the compulsory share. This is according to the bienésimo négociable doctrine applicable in Switzerland. How shall you deal with this? What planning options do you have? Find out by watching this video. My name is Tamara Frener. I am an independent attorney at law in the canton of Zurich, Switzerland. If this video appeals to you, please like and share it. According to the Swiss Federal Tribunal, there is an entitlement to a compulsory share in easy realizable assets. In other words, the liquidity of an heir's claim to a compulsory portion is protected. This becomes relevant if the estate contains a family business, be it a joint company or a limited liability company. The federal court decision was expanded upon in the bienésimo négociable doctrine. It extended to include minority pacts of registered shares in family businesses, as restricted transferability is not acceptable. This is followed by an expansion to include minority investments in family businesses. Now, what does that mean? Minority shares in a company are often not tradable because there is no liquid market. Thus, shareholders with minority stakes are locked in. An heir to a statutory share does not have to accept such minority interest as part of his compulsory portion. He can refer to the bienésimo négociable doctrine. An indemnity is due at the time of the division of the estate. The company successor must take over the minority shares and financially compensate the co-heirs. The statutory entitlement must be satisfied. So, business owners, what are your planning options? Try to reach an amicable arrangement with all heirs. An inheritance contract and a shareholder pooling agreement are instruments to consider to transfer the business as smooth as possible when the owner passes away. This is especially true if the company is the main asset and there is no further estate property. An inheritance contract with a partial waiver of compulsory portion comes into question. It can be bindingly regulated who will be the company successor. The share in the company must be distributed, as should the remaining assets of a future estate. Compensatory agreements must be made. The remaining heirs generally only agree to a partial waiver of the compulsory portion if they receive other assets or appropriate consideration, also known as foris familiation. The interest of co-heirs or minority shareholders must be protected. This is the case when one successor receives a majority share and the other heirs are allocated a minority share. The minority shareholders should have rights that are set out, for example, in a shareholder pooling agreement. It is advisable to combine an inheritance contract with a shareholder pooling agreement. The corporate regulations must also be recorded in the inheritance contract. Involve the heirs to the compulsory portion during your lifetime. Shares will be transferred to them. They must conclude a shareholder pooling agreement. This shareholder pooling agreement can regulate the current and future shareholding status between one and more contracting parties. This only has an effect between the parties, inter partes. Ideally, all shareholders are bound as contracting parties. If necessary, include enforcement measures, such as the deposit of shares or the appointment of a representative. The idea is that all act in concert, that all pull together, involve every single heir if possible. So now, what are the possible contents of a shareholder pooling agreement? the objective of what the family owners intend, the principles of business policy, and the financing of the company, the protection of the claims of minority shareholders. Do you have a right to representation on the board? A right to a minimum dividend? Do you have the right to sell the minority shareholding to the company successor after a certain period of time? A voting commitment on the part of shareholders obliges them, for example, to vote for a proposed board of directors. How should the retained earnings be distributed? How many dividends will be paid out? How to value a company? How to determine the price of the shares? Are the rights of first offer of preemption and tag along when transferring shares? What events can trigger involuntary transfers? Then legal succession regulations must be provided for instance, what happens to the shareholder shares in the event of the death, divorce, or bankruptcy? Do co-shareholders have any purchase obligations? Furthermore, non-competition clauses and confidentiality obligations, also known as secrecy obligation, are provided for. To be on the safe side, observe the legally binding form. In this way, you avoid discussions as to whether the clauses are dispositions inter vivos or dispositions mortis causa. Anyone who is already a shareholder during its lifetime and has signed a shareholder pooling agreement cannot later invoke the biennesimo négociable doctrine after the patron's death. If so, the minority shareholder could be accused of contradictory behavior. So, please note down, what is your life situation? Is the family integrated into the management of the company? Who is active? Who invests and lets third parties manage? Who is on the board of directors and who is in the management? Do you need an independent sparring partner? Give me a call. And please follow me on social media, be it YouTube, Facebook, or LinkedIn, so you will not miss any news or insight.